Can you define for us what a manifest educational hardship is?
I will do my best, because fortunately, this is one I don't have to define myself, because the State Department of Education has done so in ED 320. ED 320 is the state rule. ED 320 are the State Department of Education's rules that have the same force and effect of law that are adopted by the State Department of Education to implement the laws that the legislature has passed. So it's we call it a rule, you can call it a regulation. If a parent or guardian thinks the attendance of a child at a school to which such child has been assigned will result in a manifest educational hardship to the child, a parent or guardian may apply to the school board for a change of school assignment to attend another public school in the same district or attend a public school in another school district. In order to apply for the school, to the school board for a change of school assignment based on manifest educational hardship, a parent shall demonstrate the detrimental or negative effect on the pupil if the pupil continues to attend the school to which he or she is assigned. If a school board determines that manifest educational hardship has been found, the school board shall issue a waiver of the school assignment. That's essentially what they do. And the student shall be reassigned to a reasonably available public school in the district or in another district. So they waive the assignment. So they've said the school board ultimately decides, kids, you're going here, or this youngster is going to go to this school, and the school board would issue a waiver. Here's the thing. Each school board shall establish a policy which shall allow a school board, with the recommendation of the superintendent, to take appropriate action, including but not limited to assignment to a public school in another district when manifest educational hardship is shown. I'm giving you the whole thing because it's not very long. Now, the local school board issuing a finding of manifest educational hardship, well, no, excuse me, I'll read it correctly. The local school board shall issue a finding of manifest educational hardship if it determines that there is clear and convincing evidence. And I'll just talk about that very briefly because all these words are important. Clear and convincing evidence is not a preponderance of the evidence. Clear and convincing evidence, so it's higher than a preponderance of the evidence, which is a basic weighing of the evidence, and once the evidence is weighed, it tips slightly in one favor or another. Clear and convincing is that the scales of justice are tipped, and you can see them tipped. The other standard of proof that you have in cases is beyond a reasonable doubt. You hear that all the time on your police shows. Beyond a reasonable doubt is the jury has no reasonable doubt, the trier of fact has absolutely no reasonable doubt. These are the facts. So, just letting you know that. And the standard is this, that a substantial portion of a pupil's academic, physical, personal, and social needs, all four of those things, a substantial portion of a pupil's academic, physical, personal, and social needs cannot be met by the assigned school and are not found within the student body of the assigned school. Number two, that the assigned school's failure to meet the pupil's needs will impair the educational progress of the pupil. And number three, that another public school, either within the district or in another district, may reasonably meet the pupil's educational needs. The last section is, if a parent or guardian is aggrieved by the decision of the school board, it can appeal to the state board in accordance with the provisions of ED 200. Okay? You want me to go over that one more time, or did you get them all? So the standard is clear and convincing evidence of, number one, a substantial portion of the pupil's academic, physical, personal, and social needs cannot be met by the assigned school or are not found within the student body of the assigned school. Number two, that the assigned school's failure to meet the pupil's needs will impair the educational progress of the pupil. And number three, that another public school, either within the district or another district, may reasonably meet the pupil's educational needs.